The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Be seated. I want to welcome everyone to the Fourth Circuit Court of Appeals this morning. We have two interesting cases, and good lawyers. We look forward to hearing it. In the first case, number 22-1399. Madam Clerk, you want to call the case for us?
The court calls case number 22-1399, Judith A. Shears versus Ethicon, Inc. et al.
Mr. Foster? Good to have you with us, sir.
Good to be here, Your Honor. May it please the court, my name is Jason Foster. Seated to my left is my partner, Ed Amos, and our firm represents the Shears in this appeal. Our first assignment of error deals with a grant of summary judgment in Ethicon's favor on the Shears design defect claim, strict liability claim.
I read that as a exclusion of an expert witness issue, and you called it a summary judgment.
That's correct, Your Honor.
Was it ever an order entered that characterized it as a summary judgment?
There was your order, and it was done orally on the record. There was no written order, but it was
Never
done.
an order entered that called it a summary judgment.
Well, Mr. Shears, I have the same question as Judge King. I agree with you, the written order does not grant summary judgment. Where in the oral order does the judge grant summary judgment? While you look, I guess I'll say what I read the court as doing is excluding your expert under Daubert and then saying, how are you going to prove your strict liability claim? And then your client says, we'll proceed under the manufacturing defect theory. But I don't ever see the district judge say, I am granting summary judgment.
Give me one moment, Your Honor.
And if that be the case, where are you now?
It would be a similar argument, Your Honor, because the whole, if it was not a summary judgment issue, the testimony was excluded based on an erroneous legal standard requiring expert testimony to show the existence of a feasible alternative design that would have eliminated the risk of injury. That has never been the law in West Virginia.
Right, but if you have a design defect claim, what's the finality to that claim for our purposes?
So the finality to that claim would be to examine the evidence that we presented at trial showing a design defect. And if, in fact, that evidence creates a genuine issue of material fact, we would ask the court to reverse.
But you don't have an expert.
We do have an expert, Your Honor.
All right, now which one is that?
We have two, actually, Drs. Kling and Rosenweig, but they were excluded because their testimony said that the alternative designs were safer.
Were they excluded or their opinions were excluded?
Those opinions on the design defect were excluded, Your Honor.
Opinions, and they had opinions on other claims
That is correct,
that
Your
were
Honor.
admitted.
That is correct, Your Honor.
Okay. But calling it, characterizing it as a summary judgment rather than as a Daubert evidentiary ruling would change the standard of review for appeal, correct?
That is correct, Your Honor.
In your favor, it would make it a de novo review. If it's a summary judgment, it would be an abuse of discretion review if it's an evidentiary ruling.
Correct, Your Honor. And we believe under either
Is
standard.
that the reason you want it characterized as a summary judgment when it's not one?
It is not, Your Honor. It's a mistake on my part if it's not in the record. It was my understanding after reading.
You said the court said it from the bench.
I believed I had read that, but apparently I'm mistaken.
Oh, okay.
But
But it might not make really any difference in the final analysis because and the error of law would be what you claim it is.
correct, Your Honor.
Would be by definition an abuse of discretion.
That is correct, Your Honor. And again, my apologies for misinterpreting the record.
You don't have to apologize for anything. You go right ahead.
Well, though, is there then a forfeiture problem? Because I read your opening brief and I don't see an argument that district court erred in an evidentiary ruling. That argument isn't in your opening brief.
But our argument is that we presented evidence, sufficient evidence, under the proper legal standard.
But that's an argument that you presented sufficient evidence to survive. I mean, I agree they're very closely related, but I guess the question that the district court erred in excluding a witness under Rule 702 is not the same as the argument that the district court erred in granting summary judgment under Rule 56.
That is correct, Your Honor, but it's our position that the outcome is the same either way, because under the abuse of discretion standard, it is a clear error of law.
And it's confined to what, maybe I'll characterize it as the elimination theory? Elimination?
I'm sorry, I'm not sure if I follow.
Elimination theory.
Correct.
The instruction says that the theory needs to be, that it needs to eliminate.
Correct, Your
Be
Honor.
eliminated, and you're saying that's not in the, that's an error, an erroneous instruction.
That's exactly right, Your
That this
Honor.
committee wrote up a proposed instruction 411, which is not supported by West Virginia law.
That's correct, Your Honor.
That's the issue you try to raise here.
Correct, Your Honor.
That's a legal error. That instruction is simply not legally correct.
Correct, Your Honor. And the controlling legal standard was announced by the West Virginia Supreme Court in the seminal case of Black and Decker, Morningstar versus Black and Decker. And to prove a product design defect, you need only show that the product was not reasonably safe.
Morningstar is in pretty general terms. I think everybody agrees to that. It seems like to me the crux of the matter on this particular issue with the design defect is that you have pattern jury instructions, may or may not be right, but they're pattern jury instructions that, as I understand it, are essentially owned by the West Virginia Supreme Court of Appeals and copyrighted by them. And your argument is that a federal court should tell the West Virginia Supreme Court that their instructions are wrong.
Not at all, Your Honor. And I would like to clear up any
It's
misconceptions.
supposed to be West Virginia law. You want the federal court to tell them, the Supreme Court, what the West Virginia law is.
I do not, Your Honor. I want the federal court to apply West Virginia law, not the West Virginia pattern jury instructions, because the West Virginia pattern jury instructions are not the law, unequivocally.
You see the dilemma that it places the federal court in, that you may be right in terms of the law of West Virginia, but I can't recall any case where there are state pattern jury instructions where we have said, well, those are wrong as a matter of state law, which begs the question of why shouldn't we let the West Virginia Supreme Court tell us what the answer is?
Because we already have the answer, Your Honor. The West Virginia pattern jury instructions were never adopted by the state Supreme Court. They were written by a single justice of the Supreme Court. There is no committee that ever approved them. That was done by a single.
I thought they had a blue ribbon committee of 30 or so lawyers. I've looked at it. I'm from West Virginia. I know a lot of these folks. It's some of the best lawyers in West Virginia.
That's
and all
correct.
of them are blue chip.
That's correct, Your Honor. In each
Both sides of the fence, every direction.
in each
It
chapter.
wasn't just a person, the Chief Justice.
I understand that completely, Your Honor. And each chapter was assigned to a subcommittee of attorneys.
Is all this in the record of how that committee operated? Or you're telling us how it was, maybe you remember it, but does the record of this case reflect how the committee operated?
It reflects how it operated for the product liability section of the pattern jury instructions, which was headed by Ethicon's local counsel in this
You
case.
say Philip Combs was the reporter.
That's correct, which means he was
You say that the reporter wrote these instructions with respect to product liability. And you say that they were reviewed, somebody says they were reviewed by two so-called reviewers, and there were 15 reporters and 15 reviewers, and at least two of the reviewers reviewed the work of the reporter. Does the record show who those reviewers were?
I'm not sure, Your Honor. I have to go back and look at the appendix on that. I do know they are listed in the pattern jury instructions.
Could I just ask you a factual question? Are you aware of any case where the Supreme Court of Appeals of West Virginia has said that the pattern jury instructions misstate state law?
No, but I am aware.
So you're asking us to predict that for the first time, apparently in history, they would say these pattern jury instructions misstate state law.
Your Honor, what I would do is direct you to the preface to the West Virginia pattern jury instructions.
No, I completely understand they're not binding, they're not controlling. The Supreme Court of West Virginia would be completely at liberty to do that. Let me posit all of that is true. But you're asking us to predict, which is all we can really do under Erie, is to predict what the Supreme Court of the state would say. You're asking us to predict, as Judge Agee said, that the West Virginia Supreme Court of Appeals would say these pattern jury instructions get state law wrong, even though you can't cite an example where the Supreme Court of Appeals of West Virginia has ever done that before.
Your Honor, what I can do is cite the controlling West Virginia law that is contrary to the pattern jury instructions.
Has anybody moved to certify this issue or some related issue to the Supreme Court of Appeals of West Virginia?
On this particular issue, or to challenge the jury
In this
instructions?
case, that's what the one that's on appeal.
We have not, Your Honor, and because West Virginia law is clear on the matter.
You may have not, but I thought Ethicon had.
I'm not aware of that, Your Honor.
That's my question. Did anyone? Okay, well, she can explain that too, but I'm saying in this case, was there a motion to certify?
None that I'm aware of, Your Honor.
Does this court, we have authority to do it on our own motion, I assume?
The court does have the authority, I believe so. Under West Virginia statute, we would certainly accept, our Supreme Court would certainly accept a certified question from this court. However, it's our position that it's unnecessary. And if I may go back, again, West Virginia Constitution says.
What if we think that you're wrong, that part is unnecessary? Have you ever specified what the issue is that you would have certified?
Never in what I would put into an appellate brief. I haven't formulated a precise question, but it would be very similar to the issues with regard to this pattern jury instruction and whether or not there is a requirement to show a feasible alternative design that would eliminate the risk of injury. But again, if I may go back, I think we're getting ahead of ourselves. The federal courts in this case must apply West Virginia law.
Well, but before we apply, we need to know what it is.
And the law is in.
And if hypothetically, if we were to say we want to certify the appropriate question or questions to the Supreme Court of Appeals of West Virginia, can you tell me what the question or questions are?
So for this particular case, on the design defect case, under Morningstar versus Black & Decker and its progeny, does a plaintiff alleging a strict liability design defect need to prove the existence of a feasible alternative design that would have eliminated the risk of injury? That would be the question I would certify.
In other words, is the pattern jury instruction right or wrong?
I'm sorry, Your Honor?
I said, in other words, is the pattern jury instruction right or wrong?
Correct, Your Honor. But we don't need to go to that step because Morningstar tells us it's wrong. And there's no case in West Virginia that says
you don't want a certification, and you just want us to say Morningstar takes care of it.
That's correct, Your Honor.
And Morningstar was a response to a certification
It was, Your Honor.
from Judge Copenhagen.
Correct.
Could I ask you about your negligence claim? Why haven't you just forfeited any argument that any error wasn't harmless by that part of your brief where it says, you know what I'm talking about? It's on page 47 of your brief. It said, we presented the following evidence, followed by nothing. So why doesn't that just mean you but why isn't the answer on negligence to say any conceivable error was harmless because the appellants completely failed to respond to the argument that it was harmless?
Because it appears in our reply, Your Honor, and that was simply an oversight on our part. It was introduced at trial. It was considered by the jury. The evidence that was submitted does appear in our reply brief with a footnote. Again, that was complete oversight. And again, going back to the negligence claim,
But we've said over and over again, you can't make arguments for the first time in your reply brief because it deprives the appellee of the opportunity to respond to them.
that's true, Your Honor, but we aren't making additional argument in our reply brief. We're just supplying the evidence that's been in the record all along. It was presented.
How does the appellee, not in your, just in your case, but in any case, if the brief says, we introduced this evidence and this shows that we're entitled to the negligence instruction that we wanted, but there's nothing there, how does an appellee respond to that?
Because they were there when the original jury instructions were argued.
Right, but you're in the Court of Appeals, you're not in the district court anymore.
I understand, Your Honor, and the entire record is part in the joint appendix. So all that evidence is there, all the argument regarding those jury instructions are in there. Our alternative jury instruction that was rejected is in the record, and all the testimony from the expert witnesses for the shears is part of the record. So to the extent that it doesn't appear in the brief, it certainly appears in the joint appendix. And again, going back to the question of negligence, again, those instructions, I'm coming down to my last 10 seconds. However, the negligence instruction improperly blended strict liability and negligence together. For strict liability, you look at things like state of the art. You look at things like feasible alternative designs. You look at the risk utility test. For negligence, the focus is not on the product itself, but instead on the conduct of the manufacturer.
But your negligence claim is solely a negligent design claim, correct?
It is based on a negligent design claim, that's correct, Your Honor. But that the manufacturer acted negligently
Right.
by
but
using that
You've
design.
not made a claim that there was some defect in the manufacturing process.
Other than under the malfunction theory, Your Honor. And that was our second assignment of error. And again, I see that I'm over my time, but I'll be happy
Answer
to.
questions as long as there are
Thank you, Your Honor.
questions posed to you. Go right ahead.
So again, under the malfunction theory, a plaintiff can use circumstantial evidence to prove a defect, either design or manufacturing. And under that standard, the standard is
My question was getting to, there's no evidence that there was some defect in the manufacturing process.
That's correct, Your Honor.
You're back to, this was a defective design, and the standard there, as I understand those issues, is that there has to be, it has to be something that's proven that happens out of the ordinary. And my recollection is that there was evidence even from your own witnesses that this degradation process for the mesh was always a risk in any type of surgery of that type.
That's correct, Your Honor. And that just goes to show that you can't always eliminate the risk of injury, but you can make a product safer. And that goes back to the pattern jury instruction 411.
And this was one of 37 or 38 cases in West Virginia?
I'm not sure the total number that came out of the consolidated cases, Your Honor. So I'm afraid I don't have that information.
Is this the only one that's been tried?
It's the only one that we're aware of being tried, Your Honor, that our firm served as local counsel for.
Will you say some time? Thank you, Mr. Foster.
Thank you, Your Honor.
Ms. Pepke, good to have you with us.
Good morning, Your Honors. May it please the Court, my name is Amy Pepke, and I represent the appellees Johnson & Johnson and Ethicon. Contrary to what we just heard, every issue before this Court today can be resolved by Fourth Circuit or West Virginia Supreme Court precedent. Everyone. This Court should affirm the judgment below for 3 reasons. First, on the strict liability claim, the testimony was properly excluded because Mullins 2.
This is your strict liability design defect.
Yes, Your Honor. The evidence was the testimony of their experts was properly excluded because Mullins 2 correctly applied this court's precedent in predicting what West Virginia Supreme Court would do. But alternatively, this court can reach the exact same result by applying Neese, this court's case, Neese, and Church versus Wesson, because plaintiff presented no reliable evidence that their alternatives were safer or feasible in 2009.
Right, well, the instruction on the design defect, if I'm recollecting correctly, contained the elimination language.
It did, Your Honor.
And you won't find that in Neese.
You won't find that
As I
in Neese.
recall, in Neese, the language was something to the effect of, and I'm just going to paraphrase here, even though I was on that case, it's very, very hard in that type of a design defect case to prove it unless you can show the safer alternative design. But there was no language in Neese that embraced the elimination concept.
Right, so that gets to the crux. I'm going to jump ahead. I was going to go through my roadmap, but let's just get to the crux of the issue here. First, I do want to take a second to address the waiver issue because I think it's significant. This court correctly observed that this testimony.
You're on the negligence claim.
I know, Your Honor, there was a waiver issue on the strict liability claim.
Now, what waiver are you talking about?
It as the
Who
court.
waived what, when?
So on the strict liability.
Waiver issue.
So on the strict liability claim, that testimony was excluded in a Daubert order. That Daubert order.
That's what we were talking about earlier.
Yes,
They said
exactly.
It was a Daubert ruling
Yes.
to exclude the,
Testimony of their experts on feasible alternative design because it didn't eliminate. That order is document 155, and it wasn't part of the appendix. It's not part of plaintiff's appeal. They did not appeal from the exclusion order under Daubert. So I think they have a serious waiver issue. But I want to go on and address the substantive issue of elimination.
all you had to do in the federal courts, file a notice of appeal, and then you could raise issues where the court ruled against you.
Well, they could have raised it, but they didn't address it at all. It's not in their appendix. Document
They
155.
characterized it as a summary judgment.
They do characterize it as a summary judgment, and that's,
You agree that's what that there's a characterization of it as a summary
yes,
judgment?
that is how they characterize
That's a
it.
mischaracterization.
It is a mischaracterization. Well, there was, yes, they just don't even address
But if
it.
we assume we have something in front of us.
Right.
Which we do, why don't you talk to us about why we shouldn't let the West Virginia Supreme Court of Appeals settle all this? Because this isn't going to be the first case where these issues come up.
Your Honor, there's no need to do that, to certify the question, because Mullins 2, Judge
Did
Goodwin.
you ask that your client, didn't they raise certification?
We did not request certification, Your Honor.
In this case or in Mullins?
raised
I
certification?
thought somebody did somewhere.
Not on this issue that I'm aware of, and I think I've been involved in the case since it was back in the MDL.
Was it raised in a related case?
We have raised,
There are 30-some thousand of the cases.
right.
All right, and.
But this particular
I mean,
issue,
But this would be a rifle shot at West Virginia, but not all of them are West Virginia cases.
that is absolutely correct. So the 37 that were consolidated were
Now, what they are,
consolidated.
37 West Virginia?
Yes. So they
37 West Virginia cases.
Yes.
And was certification raised in connection with somewhere in the 37 cases?
No, not for this issue, because our position has always been that Mullins 2 correctly predicted what,
Mullins 2 at this Judge Goodwin's
yes,
2016,
late 2016.
Opinion.
Yes.
you're resting on it. And he says that this elimination stuff's not covered, and he's making an educated guess.
Oh, I think it's more than an educated guess, Your Honor. So he
You want us, just to be clear, you want us to defer to an unpublished federal district court decision about what the Supreme Court of West Virginia would say?
Well, that's part of the authority, but no, Your Honor.
You're saying he got it right.
I'm saying he got it right because he followed this court's law in Liberty Mutual, the Erie law that says,
But his is not precedent
no, Your Honor.
of what West Virginia law is. The West Virginia, the Supreme Court of Appeals would have to say that.
Right, Your Honor.
Did you say that this instruction 411 should be deferred to, as it's in those proposed, or the instructions?
Under Liberty Mutual, yes, Your Honor, that is the duty of this court.
That Liberty Mutual case, yeah, that's our case, isn't it?
Yes, it is. Under Liberty Mutual,
He talks about, Judge Niemeyer talks about policies. Is that what you say this is?
yes, under
Well,
Liberty.
when was it adopted by the Supreme Court?
Well, Your Honor,
He says policies adopted by the court, didn't he?
I
When
believe.
was this one adopted by the Supreme Court?
Under Liberty Mutual, the language that I'm referring to is that this court, in predicting what West Virginia should do, they should consider, among other things, canons of construction regularly applied by the courts of the state and whose use for a particular purpose is approved by the state's highest court. Now, if we look at the pattern jury instructions on the court, they are on the court's website. You purchased them from the West Virginia Supreme Court. As they state on their website, they went
Are
through.
these copyrighted to the Supreme Court of Appeals?
I don't know if it checks the copyright on that.
Well, that's not an essential factor, but it's the, I think as I ask opposing counsel.
Yes, it is.
You can see the, for lack of a better word, angst that it may cause a federal court in this situation to be telling the West Virginia courts that we know their law even though they haven't expressed it, or to say that we find your pattern jury instructions wrong as a matter of state law.
Absolutely, and it should create angst. That's exactly what the plaintiffs are asking this court to do, is to find them in error.
You're asking us to adopt them, or to say that they weren't, that they're the law of West Virginia, even though they weren't litigated. There was no adversary process involved in deciding the language, the terminology of instruction 411.
I'm asking the court to follow Liberty Mutual and
They would be at best an advisory opinion.
they would be persuasive authority, which Liberty
They might
Mutual.
be persuasive authority.
Yes,
All
which-
right, you can argue they're persuasive authority.
Yes, and
But
which-
even then, why would we not want we have a advisory justice system, an adversary justice system, and they weren't subjected to that.
Well, let me get you
Weren't
there.
subjected to that.
Your Honor, let me get you there a different way. So not only is 411 persuasive authority, and I can go through why they are, and I'm not going to weigh into the attacks on Phil Combs because I think your honors know that that's a baseless attack, and these committees were made up a lot of people, a lot of blue chip people on both sides, including a partner at his firm was on the committee for the pattern jury instructions. But 411 is actually correct. And it's correct. The answer has been hiding in plain sight. And I'm actually surprised I didn't see it before. But it's in Morningstar.
It's in Morningstar.
It's in Morningstar.
Elimination theory is in Morningstar.
Note 20. So Morningstar, which is an amazing case, right? We all want to say that Morningstar is a strict liability case, and it's not.
Say footnote 20?
Yes, Your Honor. It's so much more than that. So Morningstar addresses negligence. It addresses strict liability. It addresses policy. And in note 20, it's discussing the risk utility test that it is adopting. And number 4, the manufacturer's ability to eliminate the unsafe character of the product. It's right in Morningstar. And Justice Ketchum, he followed Morningstar. He cited it quite a lot in the pattern jury instructions, and it's cited in 411. And what is also interesting is when Morningstar adopts this test, Morningstar is a forward-thinking case, right? So it says, I'm not going to follow the restatement exactly. I'm not going to follow these California cases and everything exactly. In fact, what the court says is we're going to adopt a risk utility test, and you know what? We acknowledge ours is more restrictive. Right there. on 684, or 891 if you're using the West Virginia Reporter, it's a more restrictive
I haven't looked at
test.
this before, but just looking at it right now, it looks like footnote 20 is explaining 7 factors that were proposed by 2 scholars, Dean Keaton and Dean Wade. Are you saying somewhere in here the court is adopting these?
Yes, on page 887, actually it's 886 and 887, which is where footnote 20 is mentioned. It refers to the risk utility test, and then it says in the next line, we believe that a risk utility analysis has a place in tort product liability by setting the general contours of relevant expert testimony concerning the defectiveness of the product. So that, I believe, is where 411 draws the elimination language if we're looking.
Right, but that, maybe I dismissed all this before, but I don't remember anybody briefing this point.
No, Your Honor, I wish
Hold on a second. I'm not seeing the court say, we now hereby adopt this 7-factor proposal from Dean Keaton and Dean Wade.
I don't think it says it in that language. It certainly says this is the risk utility test we're looking at, and I believe you'll find that that's the risk utility factors that courts have applied. But again, I want the court to go back to Liberty Mutual. The job here of this court is to predict what the West Virginia Supreme Court would do. And if you look at the pattern jury instructions, which are persuasive, and you look at Morningstar, you have what you need to predict what the West Virginia courts would do. Now, Your Honor, I want to just briefly move on and state that you can get there alternatively without certifying the question, because they also fail in their proof of that the alternative was safer or feasible in 2009. And that's under this court's Nice holding that their proof has to be more than a theory. All they have done is theorize that their alternatives, UltraPro and PVDF, would actually work as a stress urinary incontinence device. That fails under Nice. It fails actually under Church versus Wesson as well in West Virginia. In fact,
Did the district court make that finding that you're just describing?
The district court did not, though we asked them to repeatedly. We asked Judge Goodwin in our motion to exclude the experts, which can be found in the record at 3061. We again asked in the Daubert hearing in front of Judge Keeley, the district court, at 5561 through 65. We again asked the court in our Rule 50 motion at 6818, and again during argument before the court at 6748. We continually said that Nice would have excluded their alternatives because they were not reliable and they did not provide evidence that they were safer or could work as a midurethral sling. Now, at best, what they did is say, hey, we don't like your material. We think you should use this other material. Now, the TVT device isn't just material. It's instruments. There's some material between the instruments, and it's covered by a sheath. And they just said, hey, yank that material out. We have a better material. But all they did is say, our material addresses this one little issue that we have an issue with. It's degradation. What they didn't do is say, hey, it would also fix stress urinary incontinence. And they didn't prove that at all. And the best analogy I have is this. My husband works in the construction industry. And his uniform, so to speak, is heavy denim overalls. And he wears those for a reason because they protect his body. But they're hot. And he overheats in them in the summer. And they're scratchy and they irritate his skin. Well, I've got a fix for that. There's this great other material over here. It's silk. Silk is lightweight. It's not going to irritate the skin. It breathes in the summer. So we should put him in silk for his construction work, right? No, because it doesn't meet the ultimate purpose of what he needs to protect his body, and that's what they've done. They've said, hey, there's a great other material here, UltraPro and PVDF, just slap it in there.
So you, basically on this line of argument, you want us to make a finding that the district court didn't make?
Yes, Your Honor, it's an alternative grounds that we preserved and repeatedly asked the court to make. You could do it because the testimony isn't reliable, because even their experts say that UltraPro, for example, isn't suitable for use in the pelvic space. There were no evidence that from any expert that it was available for use as a stress urinary product in 2009 when this
But this kind of Daubert argument, Judge King mentioned before that to the extent the judge excluded it on the grounds that the judge was wrong about the law, that's something we'd review de novo. But you're now saying this evidence isn't reliable, it doesn't actually show that. That's the kind of Daubert ruling we would give like full abuse of discretion review to the district judge for, right? And I'm not sure we can affirm on an alternative grounds of something that would been reviewed for abuse of discretion had the district court ruled on it.
I think you could affirm on alternative grounds the dismissal of the claim because the evidence would not have supported a jury verdict. They just didn't have evidence.
Order entered dismissing the claim?
To the extent that the court finds that there was, you could affirm it. I do believe that there were a couple of points in the
You
transcript.
said there was an order about the Daubert ruling.
There is an order on the Daubert. There are a couple of points in the transcript.
Nothing that said summary judgment.
There is nothing that says summary judgment. Your Honor, I'm getting,
And they've said that in their opening brief, that it was a summary judgment ruling, and you didn't correct it in your brief.
we did not, and I apologize, Your Honor, I'm correcting them now.
So you have
I was
right on the,
confused reading these briefs. I'm sorry, go ahead.
you have a jury verdict on the negligence claim.
Yes.
Right.
So I want to get to
So, well,
that.
wait a minute. So what order in the record disposes of the design defect and the malfunction circumstantial evidence claims?
So the design defect, she excluded the evidence. For strict liability design defect, she excluded the evidence, and it kind of just unfolded from there that we assumed, not we, plaintiffs assumed, based on Judge Keeley's recommendation, that meant that their strict liability design defect claim was gone.
Can I jump just to the malfunctioning theory? Am I correct in recalling the district court granted JMOL for you on that, right?
That is correct.
Okay, so there's an order of the district court that
Yes.
gets rid of the manufacturing defect theory.
Yes.
The malfunction theory.
And she was correct in that. I'm running out of time, and we've got a lot to
As
cover.
long as you get questions,
Good,
right ahead now.
great.
we want to figure this thing out.
Oh, it is complicated, right?
We want to understand this. There's stuff here that's kind of confusing.
Absolutely.
So why don't you tell us a little bit about the malfunction theory part of it and the waiver issue on the negligence claim?
Do you mind if I start with the negligence claim?
Go right ahead.
Absolutely. The negligence
I
design,
thought the malfunction theory was their backup theory.
it is.
when
They
the judge-
pivoted.
When the judge wouldn't let their experts say what they wanted to say.
That is absolutely correct, Your Honor. They pivoted to malfunction theory. It actually had not been,
So the claim was still there and went to the jury, and tried on the malfunction theory.
yes, Your Honor.
And then it was, at the conclusion of the trial, it was thrown out on the directed verdict that they call now the JMOL.
Rule 50 JMLL, yes.
Before they
Did the
changed
malfunction
name of
theory
it.
go to the jury, though?
No, Your
I thought
Honor.
you got judgment on that.
It was under the judgment as a matter of law before it went to the jury, but it was tried.
They didn't let it go to the jury
That's correct.
because they weren't able to say that the elimination theory was satisfied.
Correct.
If the expert had said that, I would think that Judge Keeley let it go to the jury.
I believe she would have, but she correctly,
And she didn't let that come in because of Judge Goodwin's ruling in 2016 that you cited.
No.
You called the second Mullins opinion, I think.
Mullins too. No,
Mullins 2 was what she relied on
for the malfunction theory? No, Your Honor.
to
Sorry.
keep out the evidence.
No, so this is really
Because it
interesting.
didn't say the elimination theory. That was the
No.
basis of the Daubert ruling.
So this is really interesting. So all of that evidence on safer alternative design, all of the evidence ended up coming in anyway because plaintiffs argued that safer alternative design evidence, even though it was excluded for strict liability, was relevant to their negligent design claim. So they made that argument and Judge Keeley agreed. So the evidence ended up coming in for their negligence claim, which is why it's very ironic that they are now here today.
That was the claim that went to the jury.
That's the claim that went to the
And
jury.
you won.
And we won. The jury only reached question number 1, which was purely about negligence, and found that Ethicon was not negligent. So it didn't even get to the following instruction.
The claim on which the Daubert theory was imposed, ruling was imposed, was the one that there was a judgment as a matter of law rendered at the conclusion of the evidence.
No, Your Honor.
It wasn't entered before the trial started.
No,
With the trial, that claim went to trial on the malfunction theory.
That claim,
And then there
malfunction
was
theory,
on the malfunction theory, but and then you got an order before the case went to the jury, throwing that out.
absolutely, but the malfunction theory
So
was
it was disposed of.
it was disposed of in the Rule 50 motion, but it
Disposed
was,
of, and the adverse ruling is what they're trying to get up here.
yes, but it wasn't connected to the Daubert.
Now, what do you think about the proposition that we have authority to sua sponte, regardless of what you all say, to certify something to the Supreme Court of Appeals of West Virginia?
You absolutely have the authority to
We
do
have that
that.
authority. The only thing we'd have to do is figure out what the question is, or what the questions are. Question or questions. And you all say, both of you, we found something that you all agree on. You don't want us to do it. But if you hypothetically assume we're going to do it, would you want to try to help us frame the questions? That might be the appropriate question that ask both of you. Do you want to provide any assistance in regard to what the appropriate questions would be if we determine to issue a certification order?
Well, yes, Your Honor, if you determine
You wouldn't have to specify them today. You would be
Right.
bound by them today. You might want post-argument submissions or something, but would you want to help out a little bit on that
Absolutely.
if we were going to do it?
Absolutely.
You'd like to have your say-so.
Absolutely. Never pass up a chance to have them say so.
Okay.
But again, you don't have to do that because we got Morningstar and the pattern jury
It's
instructions.
not your position at all. You don't want us to certify. You think
it.
Morningstar takes care of it. And you cite and you rely on the footnote 20
In the
on
text.
page 600. Well, and I've looked at that again, and all that says is that the New Jersey, the state of New Jersey, I guess the Supreme Court of New Jersey, has adopted a proposed risk utility announcement or analysis as to what should be weighed to determine if a product is defective. And then they have a footnote 20 that says what the New Jersey court
Absolutely.
specified as factors to consider.
That
It's
is-
like an observation, well, this is what New Jersey did.
That
It
is-
doesn't say that this is what the state of West Virginia's Supreme Court is doing at all. It just makes an observation
It-
that
it
this
does-
is what the state of New Jersey did.
You're correct, Your Honor. It doesn't specifically say, and these are the exact ones we are going to adopt, but in the text, in the next paragraph is,
It doesn't say whether they approve it or not. It just says New Jersey did this.
I would disagree with that characterization. I believe that in the text, the court does approve of the risk utility test, and he had just cited to that risk utility test. So in Morningstar, I think it is approval. I would argue that it is approval. But I really want to get to our negligence claim.
Let me, yeah, I want you to get to that too, but help me, what's the timeline on when you got judgment as a matter of law on the malfunction theory? Was that before the case went to the jury or after? Was it before trial or before the case went to the jury?
So it was before the case went to the jury. It was allowed to be tried. At the close of plaintiff's case, I moved for a Rule 50 motion and argued the malfunction theory should be dismissed because, of course, they're
Right, and that's, that
Inherent-
that part didn't go to the jury, so.
Right.
all So tell us quickly about your negligence.
Thank you, Your
Let me
Honor.
ask one more question. You were saying it was after the plaintiff rested,
Yes, Your Honor.
before you put on the evidence.
Correct, Your Honor.
Okay, wasn't, the parties had not rested, but the plaintiff had.
That is correct. I
All
can't.
the evidence wasn't, I mean, if, lots of times judges will wait and see what the other side says.
I can't remember. Judge Keeley did reserve ruling on some portions of the Rule 50 motion, I think, but she issued it. Some rulings then, I think she came back in the next day and maybe ruled on it. It was a kind of evolving trial.
I think that's right. I think she did come back to that.
Yeah, that's my recollection as I stand here today. On the negligent design instruction, however, the one that the jury did get, plaintiff is taking issue with two parts of that negligence claim instruction. The first one is the negligent design, that's 1A in the jury instructions, and they take issue with it because of a risk utility test that's incorporated along with the safer alternative design. But it is correct. It is a proper instruction because risk utility balancing, including consideration of safer alternative design, has long been a part of West Virginia law. And I want to cite two cases to the court because they weren't, I apologize, in our brief. I could submit them in a Rule 28.
The negligence instructions talked about safer alternative design. It did not have the elimination language in it.
That is absolutely correct. And in West Virginia, in Robertson, which is 171 West Virginia 607 from 1983, that's where you see a risk utility developed for negligence. So risk utility has always been a part of negligence, even though plaintiff in their brief argues that it's not. And then in Stone versus United Engineering, 197 West Virginia 347, 1996. Look at the jury instruction in that case. It is remarkably similar to what was given here. And in that case, the West Virginia Supreme Court approved of that instruction, that is the only negligent design case that I can find post Morningstar where that was the only claim. So there wasn't a strict liability claim in it. It's a negligent product design case, and they talk about risk utility and safer.
That's what this is. I think I asked opposing counsel. There's nothing about manufacturing, failure to warn, any of that stuff. It's just negligent design.
Absolutely, and that is admitted throughout the transcript. They even say in there at one point, plaintiff says, yes, we have tried a negligent design case. And in the second part of the instruction, well, first of all, the jury, that's all, they only got to the negligent design instruction. So any errors after that, there would be no prejudice. But they also took issue with the design defect, part B of the negligence instruction, because in what they say is really interesting in their brief. They say that it is an error because defectiveness is a component of a strict liability claim, not a negligence-based product liability claim. That could not be more false. West Virginia has long required evidence of a defect in a negligence product case. It actually goes back, the earliest one I could find was 1884. So in Starks versus Baltimore, which is 77 West Virginia 93 from 1915, and it's in the syllabus, the court says, to constitute negligence warranting recovery, therefore, the defect must affirmatively appear from the proof. So defect has always been a part of negligent design defect claim. So there are no errors in the jury instructions, but the jury never got to the defect question. It stopped at negligence, which was properly instructed because it used the risk utility from Robertson. It used this instruction that was similar to Stone, and they were only asked to consider safer alternative designs, and it wasn't an elimination standard. She did not put that in there. So that was proper. I see I am well over time.
All right.
Does the court have any other questions?
We appreciate you
Absolutely. Thank you, Your Honor.
very much. Mr. Foster?
Your Honor, a lot to unpack there. I'd like to go back and address one thing about these attacks on Phil Combs. He wrote a law review article in 2011 in which he stated, with respect to the issue of whether a feasible alternative design requirement exists under West Virginia law, West Virginia Supreme Court hadn't said anything. It's been silent on it. Closest it's ever come is Church v. Wesson. And in that case, it was a design defect claim, and the court simply found in that per curiam decision that the feasible alternative design wasn't feasible. It couldn't be done at that time. There was no elimination language in the Church v. Wesson case. And then all of a sudden, Church v. Wesson is now the basis for jury instruction 411. So the reason the jury instructions...
She argued that Morningstar was the basis for 411, I thought.
If you look so for each of the pattern jury instructions, it has the case law upon which it relies.
It cites two cases.
Morningstar and Church v. Wesson.
Right, but she only argued Morningstar. That's
Church
my
v.
point.
Church v. Wesson is the other case.
Okay.
It does not have the word elimination in it. Morningstar does not have the word elimination in it. And I would like to go back to footnote 20 of Morningstar, because as Judge Agee pointed out, Morningstar is
I think Judge Goodman agreed with that too, didn't he?
So here's the interesting part, Your Honor. Judge Copenhaver in the Keffer v. Wyeth case said, hey, there's no obligation in a strict liability design defect claim to prove the existence of a feasible alternative design. It's one way to do it, but it's not the only way. And in that case, that's a really interesting case you bring up, Your Honor. That was a hormone replacement therapy case. And in that case, the plaintiffs did provide evidence that there was a safer alternative drug to the one that had been described. And Judge Copenhaver in that case found that that was sufficient. So Mullins 1 looked back to Judge Copenhaver's decision in Keffer v. Wyeth and said there's no obligation under West Virginia law to show a feasible alternative design. It was only because Ethicon asked Judge Goodwin to reconsider Mullins 1 after pattern jury instruction 411 was published.
You had what you all call Mullins 1, then you had the instructions being promulgated, whatever they were, and then you had Mullins 2, which
And that
was
was
based on a request to reconsider Mullins 1 in light of the new instructions.
That's correct, Your Honor.
And who made that motion to reconsider?
Ethicon's counsel. Ethicon's counsel?
Ethicon asked for it.
That's correct. And Ethicon's local counsel was the one who drafted that particular jury instruction. So how do you go from, in 2011, after Church v. Wesson had been on the books for over 20 years, and saying the West Virginia Supreme Court's never said one way or the other, to now 2016 saying, oh, no, there is a requirement.
Well, you're back here, you're saying Phil Combs drafted it. He was the reporter, but there were supposed to be reviewers, or supposedly were reviewers. You all say that there were at least 2 reviewers. Somebody said that.
And Your Honor, that's...
And then you had a supervising circuit judge, Judge Alsop, and then you had then Chief Justice Ketchum, what was his official capacity?
He was the Chief Justice for that year.
Chief Justice, he was running the whole thing.
He was in charge of that project, that's correct.
He was in charge of the project.
That's correct.
And you had 30 or 30-some lawyers who were the best in West Virginia. That's what you had, the blue chippers that were on the project. And they were doing that to try to assist in the efficient trial of civil cases in West Virginia. That's something like that.
That's the ivory tower version of it, Your Honor.
But that's right. And
you
were saying this 411 is error. She says explicitly it's correct. So there we are.
I understand, and if I may, Your Honor, you raise an interesting point, because under West Virginia law, under the West Virginia Constitution, the state Supreme Court is permitted, in its Article 8, Section 4, the West Virginia Supreme Court is able to issue rules and regulations regarding the practice of law. However, it's also governed by statute, West Virginia Code 51-1-4. All rules promulgated by the Supreme Court of Appeals under the authority of this section shall, before taking effect, be referred to the chairman of the Judicial Council, the president of the West Virginia Bar Association, and to the judge of every court affected thereby. None of that happened in this case. So the fact that Ethicon's local counsel was the reporter for this is all well and good with regard to the structure that Justice Ketchum set up for the publication of the pattern jury instructions, but it falls far short of the issuance of the strictures required for the issuance of an administrative order. And in fact, no administrative order has ever been entered. So the question for this court comes back to Erie, and what is West Virginia law on this issue? It's not pattern jury instruction 411, because Ethicon's own counsel said in 2011, there's no case in West Virginia that requires elimination of the risk.
It sounds to me like you now want us to certify.
Your Honor, if
There's no law in West Virginia.
that requires elimination, the controlling law is in syllabus points 4 and 5 of Morningstar. So again, to the extent the court wants to certify a question, we will be more than happy to assist and provide our input. But again, we don't believe it's necessary because, as Judge Agee pointed out, in fact, syllabus points 4 and 5 in Morningstar are vague. They do give a broad outline, and that's by design. In Morningstar, the court itself said we can't articulate a standard that's going to cover each and every possibility out there. So Morningstar syllabus points 4 and 5 are broad and flexible by design. And I want to go back again to footnote 20.
Some opposing counsel's rejoinder to that would be, well, the West Virginia Supreme Court did that when they issued the pattern jury instructions.
But the Supreme Court did not, Your Honor. The Supreme Court has never issued a single pattern jury instruction.
It's an odd circumstance. If they own the copyright and you have to get them from the West Virginia Supreme Court, it seems an odd situation as to whether or not they've issued them.
Your Honor, it goes back to our Constitution, and it goes back to that statute I just read to you.
You said they didn't do it, didn't jump through the hoops.
That's correct, Your
You
Honor.
said they didn't do it right.
It hasn't been done at all.
So you were saying they're not worth the paper they're written on.
Absolutely, Your Honor. Unless the parties agree on them, which is exactly why the preamble says it's not binding on anybody. They're binding if you agree on them and submit them to the court, but then the court's not even bound by them. They really are just that, a starting point. And if the parties disagree, they argue about them. And if the court agrees to adopt it, that becomes that goes into the jury instructions. But the preamble says, if counsel finds an error or believes they're incorrect, it's counsel's job to bring that to the court's attention. That's precisely what we've done in this case. There has never been a syllabus point that adopts the elimination theory, and the pattern jury instructions are simply one Supreme Court justice's project.
Well, if we were to decide that it'd be a good idea to certify, and if we did, and then it was subjected to the adversary process in the Supreme Court of Appeals, you'd have briefs and arguments and opinions, and we'd know what the law was.
That is correct, Your Honor. That process would certainly get us to the answer, but it's our position to be the same answer that we have in syllabus points 4 and 5 of Morningstar.
So you were saying it'd be a waste of time?
Not a waste.
A waste of legal resources to do it. That we don't need to do it. So you're still opposed to that?
I'm not opposed to, Your Honor.
We're opposed to it when you're your opening argument.
Correct. I'm not opposed to it. I just don't believe it's the most efficient way to proceed. Again.
You're not opposed to it anymore. You just don't think it's a good idea.
Just about that, Your Honor. Correct. Not the best idea. It's a good idea, but not the best idea. If the court has nothing further, I see I'm about out of time.
Thank you very much. We appreciate it.
Thank you.
We appreciate the work that you both put into it, and we appreciate your arguments. It's good to have you here. You're good lawyers, and it's a pleasure. And we will take your case under advisement. And Madam Clerk will take a very brief recess. We'll go to the next case.
Thank you, Your Honor.
Does the Honorable the Fourth Circuit.
Be seated. Madam Clerk, call the next case, please.
Next case the court will hear is case number 21-1402, Veer to Us, Inc. versus Sophos, Inc. et al.
Mr. Martin,
Yes, good morning, Your Honors, and may it please the court. Kevin Martin for the appellants, and with me
good to
today.
have you with us, sir.
Thank you, Your Honors. With me today, I have my colleague Benjamin Hayes. Your Honors, the district court found that the parties' license agreement unambiguously means something that neither party had argued it means, and on the basis of that novel interpretation, granted Virtuous its motion for summary judgment on its breach of contract claim. It then relied solely upon that finding of breach to also grant Virtuous summary judgment on the defendant's counterclaims. The district court's approach to summary judgment reached substantively incorrect results, and this court should either vacate or reverse.
Mr. Martin, can I ask you just a threshold? Are you appealing the district court's judgment that you also violated the reporting requirement?
We didn't read the district court to find that we violated the reporting requirement. With the district court, as we read the decision,
I agree. It just sort of, the district court just sort of skips over that entirely, but
I mean, it briefly addressed it. What it found was that we were obliged to report the royalty-bearing products. It found that we were not required to report the non-royalty-bearing products. And so we did not violate the reporting requirement as long as the court agrees with us as to what products are royalty-bearing or not.
And so you were also just saying, I want to just make sure the decision, I literally had to make a decision tree for this case. So if we say that the district court was wrong to conclude that there is no genuine issue of material fact about whether they are the same product, that takes out the district court's grant of summary judgment on their main claim. It resolves any issue about damages because they don't get summary judgment on their main claim. And because that was the sole basis on which the district court relied in granting summary judgment against you on your counterclaim, it also takes that out.
That's exactly right.
Now, we could, I guess, say more, but that is the least we could say, I guess, that would completely resolve this entire case?
That would completely resolve the entire case. And I want to make one distinction between the Sophos products and the Invincia products as well. The Sophos products are the only products that are at issue with respect to the damages issue and with respect to the Section 5.3.1 issue. And so if the court were to agree with us that the district court either procedurally or substantively erred with respect to the Sophos products, those two issues also come off the table.
Whether or not we agreed with you on the Invincia products.
Correct, Your Honor. And the Sophos products are the vast majority. When we briefed the issue, the Sophos products were 98% of the damages. I think it's now over 99% of the damages, and it's the only continuing damages are the Sophos products. The Invincia products, detect and prevent, the non-container Invincia products, were being phased out. That's essentially what triggered this whole litigation. After Sophos bought Invincia, it phased out the legacy Invincia products in preference for its own pre-existing modified non-container products. And at that point, seeing its revenue stream dry up, Virtuous sued, claiming that all of these products, even though they don't perform containment, are container products and services. So
I had some trouble following the ball on all these different Invincia products. But I thought there was some discussion in the district court's opinion and argument about the parties that some part of the Invincia code had been included in a number of the Sophos products.
that's correct, Your Honor. So the Invincia products, both the non-container Invincia products like detect and prevent, and the container products like spearfish protection or complete, had a body of source code. Now, what source code was enabled in any particular product was determined by a license file.
But when you're talking about the 98% damages on Sophos products, am I correct that there's something in those products that contains some part of an Invincia code?
That's right, Your Honor. So there was the Invincia machine learning source code files, the Synomics. Synomics appeared both in the Invincia container products and the Invincia non-container products. It was not enabled in the Invincia container products. It was not enabled in spearfish protection. Spearfish protection didn't employ machine learning. Cynomics has nothing to do, it was undisputed below, Cynomics has nothing to do with containment. And so the inclusion of Cynomics, the Cynomics file, in the Sophos products did not enable those Sophos products to perform containment at all.
So your argument at trial, as I understood it, was that whatever these products are, in order for Virtuous to get at them, they would have to be able to prove that they were in terms of the contract, natural evolution or derivation of products. But that's not what that's not what the district court ruled upon, and in fact, I think there's a footnote in the opinion that says, I'm not touching this.
That's exactly right, Your Honor. The district court declined to interpret that language, instead adopting this other theory of the district court's own, which was that each individual source code file, no matter what it does, is individually a container product and service, even non-container source code files like
Well,
Cynomics.
not just a container product, but one of the container products specified in the settlement agreement, right?
That's exactly right, Your Honor. And that's clearly wrong. A product is not the same as a individual file. These products consist of tens of thousands of source code files. And so to say that the accused container products are equivalent to each of their individual source code files that's not a plausible reading of the contract, and it's certainly not an unambiguously required reading of the contract, as the district court found.
So was your argument at trial, and I guess to a certain extent here, that the defined term in the contract, container products and services, it's an accused container product called Invencia X Endpoint Spearfish Protection. And if it's not that, that's not part of the defined term in the contract under its plain language. And you're going to have to use the alternative methodology of evolution and derivation.
That's correct, Your Honor. And so there's no dispute
The
that this.
district court said even though the defined term is by the name Invencia X Endpoint, I'm considering all these other products to be as if they were stated by name in the contract.
He acted as if the individual source code files are themselves products, but the individual source code files are not products. You compile 10,000 of these things, you get to a product, but Cynomics itself, sitting there alone, is not a product.
But that's not the way they were defined in the contract.
Well, the way the contract defines the container products and services are entire products by name. It's the accused container products currently known as.
That's my point. That's the way I don't know whether any of you all did the contract or not, but the contract says what it says, and it seems like to me that that's quite a stretch by the district court.
We completely agree with you, Your Honor. We think at the end of the day, there's a reason why neither party argued below that individual source code files are themselves the accused container products. It's because they clearly are
You're
not.
saying this definition is ambiguous?
Well, we think the definition unambiguously supports us, but it certainly does not unambiguously lead you to the district court's reading of the contract.
What is accused supposed to mean?
So accused is a reference to the underlying patent litigation. There's a reference to the underlying patent litigation.
How do we know that?
Well,
Other than you standing up here telling us now.
there are a couple of references to the patent litigation in the.
Is accused container products defined somewhere?
Accused container products is defined as spearfish
No, is
protection.
accused container products defined anywhere?
Outside this clause, outside this one clause that we're talking about.
Outside of this one clause, no, Your Honor. The one clause
So
says,
it's just thrown in there.
well, the one clause says the accused container products are.
No, but what's accused mean?
Accused is a reference to the patent litigation, which is referenced in the definition section of the.
Does that say that
Contract.
in there somewhere?
There's
You're
a.
saying.
No, Your Honor, there's a definition in here of the legal proceedings, and then there's a reference later on to the settlement agreement. So this license agreement was being reached concurrent with a settlement agreement to settle the legal proceedings. So
So are you saying accused, separate and apart from where it says currently called Invencia X Endpoint, et cetera, that the term accused container products is defined in the patent license agreement somewhere?
we think accused container products is defined as spearfish protection and the prior names of the products. So it's the accused container products currently called this. And so the court can ask, well, what does the accused container product say it is? It says it's this one
But
product.
there's
and its
no
predecessors.
other definition of accused container products that appears in your patent agreement.
That's correct, Your Honor. It's
Okay.
these names of these products. And again, they're
So
entire.
again, I mean,
products.
that just seems like another reason why the district court's analysis is wrong, because it seems to me that I don't know what accused container products is by looking at the four corners of the contract. I have to resort to extrinsic evidence to know what that means, and once that's true, I don't know how you can grant summary judgment.
At a minimum, Your Honor.
At a minimum,
Yeah,
maybe
we-
more,
we would-
maybe more.
We would say that it unambiguously supports us because it unambiguously means it's spearfish protection. It does not include products that it's undisputed Invincia also was selling at the time, like Detect and Prevent, that were not accused in the underlying litigation and that are not called out by name in this definition of container products and services. And so another thing the district court did wrong.
Accused sounds like it's referring to some complaint or indictment, or, we hear a lot of criminal cases here. That kind of term's thrown around in those things.
It's a term of art as well.
What are we supposed to think it is in this contract?
It's a term of art as well, Your Honor, in patent litigation to refer to the.
I know it probably is, but why isn't it in the agreement? Why wasn't it written down?
I think it was included, Your Honor, because they were, as is clear from reading the agreement as a whole, they were
Because
settling.
there were patent lawyers talking to each other.
It was patent lawyers talking to each other. With apologies to my client, Your Honor, the nerds got together. They drafted this license agreement. They used terms of art that are common in patent litigation. And accused products identified, if it simply said the accused products, that would be probably very
Products.
ambiguous. But it identifies them by name. It,
Accused container products is the term.
yeah, and it's important as well that the word container does appear both in the label and in the definition. So Invincia at the time was selling both container products and non-container products. This calls out as royalty bearing only the container products that Invincia was selling. Where this matters a lot is when you get to that Synomics file, because the Synomics file, which is the machine learning file, is undisputed. It has nothing to do with containment functionality. The district court found this in a summary judgment decision. And it also appeared in the Invincia non-container products like Detect and Prevent. And so when they argue that we took Synomics out of spearfish protection specifically, and therefore the Sophos products or the other Invincia
Well,
products.
if we conclude that the district court was not authorized to grant summary judgment to Virtuous, can we stop there?
You can stop there, Your Honor. That would resolve all of the issues in the case. It could be remanded to the district court for further proceedings, either at summary judgment or for trial if the district court decides.
That's the relief you want?
That is relief. We're asking for vacator or reversal, but we'd be very happy, Your Honor, with vacator and remand to the district court. So moving on to the other issues, though, we do think it unambiguously supports us. With respect to the damages issue, as I mentioned earlier, that would be wiped out as long as we prevail either with vacatur or reversal on the Sophos products. The same is true with section 5.3.1. With respect to our counterclaim, again, the district court's only basis for granting them summary judgment on our counterclaim was its finding that we had breached. Even if the court were to affirm the finding of breach, which we don't think you should, we think that under the best reading of Virginia law and this court's precedents, like the Bayer crop science case, it was still error for the district court to invoke that breach as the sole basis for granting summary judgment against us on our counterclaim. If there are no further questions.
Did you all have an oral argument in the district court?
There was an oral argument in the district court, Your Honor, on the summary judgment. It appears in the appendix.
Okay. I thought I recalled that.
Thank you, Your Honors.
Thank you, sir. You had some time saved. Mr. Charnas? Good to have you with us, sir.
Thank you, and may it please the court. I guess let me start with the definition. And in particular, if this court is uncomfortable with the district court's ruling, this court can affirm on alternative grounds. We argued vigorously below, as this court, as some judges alluded to, that these products were derivations, natural evolutions. It was vigorously argued by both sides below, and this court can address that and affirm on that basis as well. It would be particularly wasteful, I think, to remand for the district court to address that issue in the first instance. The parties are going to say the exact same thing to the district court on that issue that we are saying here, and when it comes back here, it's going to be
Isn't that
reviewed.
going to require all sorts of expert testimony to show that there's a derivation and an evolution for this sort of thing? I mean, the district courts seem to be pretty emphatic. The court need not interpret the definition of this term, period.
Well, correct, because the district court ruled on different grounds. I don't think you need experts on what a derivation means. In fact, the parties just argue a little bit about the definition of derivation, looking at different dictionary definitions, but I refer you to their brief. We'll take their definition on page 30 of their opening brief. They say that in the context of software products, it is difficult to imagine.
Would we be making a finding of fact in order to back up derivation and evolution?
Well, there's the facts the parties agree on. There's two files called Sinomex, and I'm referring here to the Sophos products because, as my friend said, that's 98% of the damages. So for the Sophos products, it's undisputed that there were two files that provided the machine learning capability, and that's the reason that Sophos paid $120 million for Invincia was for its machine learning technology, that they took those files and they put them in the relevant Sophos products. That's a factual question, but the parties don't disagree about that. What the parties disagree about is the meaning of the word derivations. Interpretation of a contract's a legal question under Virginia law, not a factual question.
Can I ask you about those files? So your friend on the other side said these products, these programs, whatever the heck we call them, have tons and tons of files in. I assume there's no disagreement that these programs all have tons of files in them.
They have a lot of files.
Okay, so I think we all agree. I think you're right. I think your friend on the other side agrees. The products that you're suing about have a file that is also in the Invincia X endpoint spearfish protection, right? Do we know in the record whether that common file was original to the endpoint spearfish protection or if it was originated in yet an even earlier program? Do you know what I'm saying? Like, is there a common ancestor for... What I guess I'm trying to figure out is whether this is, to go back to something Judge Agee was saying, one possibility, one explanation for why these two programs share the same file is that one is a descendant from the other. The other possibility is that they have a common ancestor.
Well, I don't think there's any dispute that Sophos, after it purchased Invincia, took the Sinomex files from Invincia's products and put them
But hold on, it's not enough that they're from Invincia's products. They have to be, according to this agreement, from Invincia X endpoint spearfish protection, not any Invincia product.
And there's no disagreement that they were from spearfish protection. Now, the interesting thing about this definition is spearfish protection is not the only product that's mentioned. There's several products, including a product called Invincia Advanced Endpoint Protection. And contrary to what my friend said, Advanced Endpoint Protection was a machine learning product. It had both container and machine learning. Refer the court to pages 73 to 74, 494, and 556 of the joint appendix. So machine learning was in the defined products, container products and services. And that file was taken from spearfish protection and placed into their product.
Well, then this just seems to me to be another argument why this is at minimum ambiguous, because as your friend on the other side put it, the nerds got together and drafted this. This definition does not say endpoint spearfish protection and advanced endpoint protection are different products. What it says is endpoint spearfish protection, currently called, is formerly known as these other three. But this definition seems to assert that all four of those things were the same thing, and now you're representing to me that is not in fact true, that these four things are not the same thing.
I think I agree with you. I think there are different iterations of it. But again, the word derivation under Virginia law, that's a legal question. What is a derivation? Now, there are facts that go into the court's application of whether the
including whether these things are actually different things or the same thing or not, right?
Yes, but I don't think that's relevant here. Again, look at their definition of evolutions. They say the only thing it can be, it's difficult to imagine what natural evolutions and derivations could be other than new products that carry forward containment source code files from an earlier generation product. Now, there are two issues there. There's carry forward files from an earlier product, and they have to be containment files. Those are two separate questions. Let me address the broader one, and then I'll go back to containment, because we disagree about that, obviously. So take out the word containment for a second, carry forward source code files from an earlier generation product. That's exactly what they did here. Now, to get to your question, there are 10, 20,000 files in a software product, but there are only a few files that provide the actual functionality, the key functionality for the file. Sinomex is only 2 files, but those 2 files provide all of the machine learning capability for the product. So it's not like they're it's not like they're 1/100th of 1% of the files.
This is trying to get around their change the font example that says,
Exactly.
read literally if the district court is right, then you literally, if you steal someone's font, you've also.
Right, and clearly the district court didn't explain in detail, but clearly that's not what the district court meant. And again, that's irrelevant, that's even irrelevant if you get to the derivations point.
So is there any stipulation of facts on any of these items you're talking about?
There were no stipulations of facts, but I also don't think the parties disagreed about these facts. The Sinomex was in spirit.
It takes me back, I think, to the first question that I asked you, or first concern that I expressed, was that to reach the points of law as you indicate they are would require the Court of Appeals to establish an entire body of facts which have never been found by the district court or stipulated to by the parties.
I don't think that's right, because our position is that the key facts are not disputed. The 2 Sinomex files were in Spearfish protection. Sophos purchased Invincia primarily to obtain that machine learning technology provided by the Sinomex files. They then took the Sinomex files and put them in the Sophos products that are at issue. Those facts, you can ask my friend when he gets back up, but I think the parties agree about that. And we say by itself, those facts establish that the 2 Sophos.
Those are great questions in the district court.
I'm sorry?
Those are great questions in the district court.
Well, but the district court's summary judgment opinion says the same thing. The court said that the Sinomex files were taken and placed into the 2 Sophos, the 2 disputed Sophos products. So I don't think there's any disagreement about that. The question is, does that make the Sophos products a derivation? And we think that it does, even if you accept their definitions of it, because the 2 key files were taken and put in the Sophos products. And that leaves the issue about whether they have to be quote-unquote container files. And we think the answer to that is plainly no. The parties could have written the definition differently to say the container product.
What do you say these accused words do?
Well, it's a little bit of a puzzle, because contrary to what my friend said, Spearfish protection was not accused in the patent litigation.
Well, right here, you disagree on the facts right now. You say,
I think.
just on that one point.
I don't think that's, I think that, but I think well, I don't know that we disagree or not. Let me just cite to the joint appendix 483 to 84, which is the expert report in the patent litigation.
If you all agree what accused container products means, why didn't you write it down, put it in a stipulation, and present it and put it in the record that came up here on appeal?
Well, I think we did disagreed about what it meant.
You disagreed.
We did disagree about what it meant. They say, for example, that they say the word container, or the description container, carries forward to natural evolutions and derivations, and we disagree with that. I think, again, I don't think we disagree about the essential facts of what is underlying the dispute.
You say that disagreement is irrelevant?
No, that disagreement is very relevant. If we're right that derivations and natural evolutions do not have to be container products, then I think that establishes by itself that the 2 Sophos products are natural evolutions and derivations. And I think, again, because I don't think there's a factual dispute about that between the parties, I don't think it's necessary, and because the interpretation of a contract is a legal question for the court, and because the parties argued this precise issue both below and in our briefs here, I don't think a remand for the district court to take a look at that legal question is necessary. So, for us, the real question, where the rubber hits the road, is whether the derivations must be container products. And we just think that that's not the case. The parties could have written this provision to say container products and services shall.
You say it's ambiguous or unambiguous?
I think it's unambiguous and supports us.
That's what I thought you'd say.
I'm glad I'm predictable, Your Honor. The parties could
The
have.
other way around.
where both yes. The parties could have said the accused container products mean spearfish protection and was previously known, as well as natural evolutions and derivations of those products that provide container technology. But it didn't do that. I mean, it's common sense and ordinary use of the English language that a second product can be a derivation of the first product, even though it provides different functionalities. I mean, a frog is a derivation of a tadpole, even though their functions are different. And the parties could clearly have made it clear that they meant that the derivations be container products. And that's particularly important because none of these products that are mentioned in the definition, spearfish or the other ones, did only one thing. I mean, these are complicated technologies that do a bunch of different things. And so
Well, but that gets to me to what another source, again, with all respect for whoever wrote this clause, I don't know what the word product means. Like, I think part of the debate between the parties and the district court is literally what is the definition of a product, and I don't know, based on the plain language of this definition, how I'm supposed to know what a product is. Is a product source code? Is a product a discrete type of functionality? Is a product, all the way at the end, right? Like, it feels like one of the many difficult questions about this case is what is the definition of a product?
Well, I don't think the parties have disagreed about what a product means. I don't think it's discussed in the briefs. I mean, I think if you can
No, but I think it's a lurking, there's lots of things where I think the parties are basically just talking past each other. And when I try to interrogate why it is I think you're talking past each other, it's like I'm not sure that anybody in this case agrees with the definition of product is.
Well,
because the district court thinks it's some random lines of code, which I've noticed that in the 15 minutes you've been up here, you've made no effort whatsoever to defend.
Well, I don't really think that's what, I think the district court was using shorthand. I don't think that's what the district court meant. I agree with you that.
So is that shorthand for derivations and evolution?
No, because the district court plainly said that he wasn't getting to derivations. He didn't need to get to derivations.
What's the shorthand for? I mean, it seems like the shorthand would be, well, the agreement has a specific product by name, doesn't include any others, therefore you then move on to evolution and derivation. So what's the shorthand here?
Well, let's be clear about the Invincia products. The Invincia products that are at issue, prevent and detect, are identical. The source code is identical to spearfish protection. So the district court was actually, he didn't focus on it, and the parties haven't up here because it's only a small percentage of the damages, but the district court was absolutely correct.
Wait, when you say it's identical, you mean literally every single line of code is the same?
That's the evidence.
That's the Evincia, not the SOFA, but that's not true of the SOFA's products.
Correct.
Okay.
Yes.
Which is 99% of the damages.
Now, counsel said, well, there's a license file that changes what's available, but as we pointed out in our brief, there's no summary judgment evidence of that at all. The only thing they cite really is our expert who says he understands, quote unquote, this is how it works. And his opening expert report says, I understand this is how it works because that's how it's been described. After their expert submitted his expert report, our expert submitted a rebuttal report and said, well, wait a second. Their expert never saw the license file. They refused to produce the license file in the litigation. Their expert in his report doesn't say the license file functions this way. There's really no basis for anyone saying the license file does this. As far as we can tell, all these products are the same. And again, that's only 1-2% of the damages. But the district court, I think, was right about that. Now, with respect to the Sophos products, I think you have to extrapolate a little bit from the district court's reasoning on that. And I think the easier course is just to go right to derivations, which, as I said, the parties argued below and here, and it's, I think, well presented. Moving on quickly to a couple of the other.
You all finished your discovery and everything here. You had full discovery.
Yes.
So if we say the summary judgment was erroneous and send it back, you all are ready to go to trial.
Well, we're ready to go to trial, yes.
Ready to go to trial, yeah. Get resolved.
Now, I suppose, what we might do, I haven't thought about this, but we might do, it goes back down, is move for summary judgment, and the other side might as well, again, on the derivations point, because the district court didn't get to that in its previous summary judgment order, and might.
You can do that, too.
And since we think it is unambiguous in our favor, they think the same, I suppose there probably would be a new round of summary judgment briefing, but I don't know, that depends on what the district court wanted to do, obviously, and it's different, we a different district judge as well. Council raised section 5.3.1. We think 531 does not apply. It has a very specific definition of an acquiring entity in sections 5.2 and 5.3. Nobody disputes that neither 5.2 nor 5.3 applies here, and therefore 5.3.1, which provides sort of a safe harbor to Sophos or to an acquiring entity, does not apply here. Now, it's true that our position is that Sophos stepped into the shoes of Invincia, but it did so not under Section 5 of the contract, but under Virginia common law. As the district court found, it was a successor in interest. District court found this in its motion to dismiss opinion, which Sophos has not appealed or has not challenged in its briefing, at least. So our position is that that's the law of the case. With respect to the counterclaim, counsel complained also that the district court, or how the district court, and the fact that the district court applied the first material breach doctrine under Virginia law, which is very well established. But again, the court can bypass the questions of law by resolving the dismissal of the counterclaim on a pleadings basis, essentially, or an evidentiary basis, I should say, which is that there's no material facts in dispute here. The fact of the matter is that Sophos sent multiple communications to Virtuous asking us to sign an agreement, but the agreement was not between us, Virtuous, and Sandboxy, which is the entity that the contract requires us to sign a contract with. Their communications expressly asked us to sign a contract with a third party called Nettainer. You can look at the agreement, the proposed agreement they sent over, which is the party site and is in the joint appendix. And you can also look at the emails that their counsel sent. Their counsel sent multiple emails asking, and I just quote one of them. He said, "Will you sign, quote, a new form of a patent license agreement between Virtuous and Nettainer," unquote. That's page 343 of the joint appendix. So they asked us to sign an agreement with Nettainer, a third party. The contract doesn't require at all us to execute any agreements with third parties. They never asked us to sign an agreement with their subsidiary Sandboxy, who they say that they were planning, or at least talking about, spinning off. The last point I want to make is let's go back to the main claim and the damages question, and this relates to what the briefs refer to as the MSP program. And this does, if the court affirms the summary judgment on the Sophos liability, this is a fairly sizable percentage of the damages that the district court awarded. And the question is whether royalties are owed on these monthly renewals in the MSP program. And the way this program works, and again, I don't think there's any dispute about the facts here, small businesses get the program, the Sophos programs, they pay on a monthly basis. If they want the product for another month, they have to pay for another month. If they don't pay for the product, their use of the product gets terminated after a month. And we think that plainly establishes, as the district court properly found, that this is a monthly renewal, and the contract is perfectly clear that renewals of existing licenses trigger the royalty obligation. Sophos argues in its brief that, well, this doesn't apply, the renewal doesn't apply here because there has to be a separate distribution of the software, and there's no redistribution to the monthly program, to the monthly users in this program. A couple of quick points about that. First of all, there's actually no evidence in the record that there's no redistribution. There's no evidence, they didn't present any evidence at all about that question. So at summary judgment, I don't think they can rely on that. And I think that's refuted by the fact that the contract expressly says that renewals of licenses by themselves without a redistribution trigger the royalty obligation. So my time is about up. If there are no further questions, thank you.
Thank you very much, Mr. Chardas. Mr. Martin?
Thank you, Your Honors. Just very briefly, on the natural evolutions and derivations issues, at best, for the other side, there's ambiguity and disputes of fact. We think that in a definition of container products and services that specifically identifies only Invincia's container products and none of Invincia's non-container products, that you cannot say that that files like Sinomics that appeared in the unnamed non-container products too are sufficient to make something a natural evolution or derivation of the container products specifically. We certainly did not agree to any definition of derivations which would pick up non-container products. Just as a factual matter, to answer a question that came up, to sort of talk about the timeline a little bit, when the license agreement was signed, this X by Invincia had already been released. There were 3 versions of X by Invincia. There was Spearfish Protection, which used containment. That gets named in the license agreement. There was also Detect and Prevent. Those had the same underlying source code files, but they did not provide containment. So they were not accused in the underlying patent infringement litigation of infringement. And they did not get named as accused container products in the license agreement. Under Virginia law, the purposeful exclusion of the non-container products, Detect and Prevent, has to be given force. You don't just ignore the fact that the parties included some things in the definition and excluded others. And so the only natural reading of that is that Detect and Prevent are not accused container products. They are not natural evolutions and derivations of the container product. It would make no sense to say that the products they decided not to name somehow get swept in the back door as natural evolutions and derivations of the product that they did name that existed at the same time. It also makes no sense to say that products that appear in unnamed programs are enough to make something a natural evolution and derivation of the named program. With respect to the counterclaim, I just want to say that there are a lot of factual disputes about the counterclaim. We did not move for summary judgment on our counterclaim, only they did, precisely because we think there were disputes of material fact. I would note, for example, at JA Appendix 344, we made clear to the other side in the email correspondence that what we really wanted to do was invoke the license agreement's contractual provision for a spinoff of Sandboxy. While we might have used Netainer, the new proposed parent, as shorthand for Sandboxy after the spinoff, we were clear about what provision in the contract we were referencing and what we were trying to do there. Unless the court has any further questions. Thank you, Your Honors.
Thank you very much. We appreciate counsel's efforts in this case. And this court has a longstanding tradition. I know some of you from way up north, at least one of you. At the conclusion of each oral argument, we come down and greet counsel in the will of the court and tell each of you personally that you've done a fine job. And we're unable to do that now because of the pandemic restrictions. And next time you come back to our court, I hope we'll be able to greet you personally and perform that honorable function. But it's good to have you here, and we thank you for your work, and we'll take your case under advisement. And with that, Madam Clerk, we will adjourn court for